All right. Good evening, everyone, and welcome to CCI Haronia's Intro to Condo course. If this is your first time that you've joined us online for one of our many courses or webinars, we're so happy that you were able to check us out today and join us. And if you have been to any of our webinars or any of our online offerings in the past, welcome back, and it's so glad that you could make it. I'm Sonja Hodis. I'm one of the many directors at CCI Haronia, and I'm a condo lawyer as well as your moderator today. And today we are joined by many directors from the CCI Haronia Board of Directors who are all going to be presenters in this webinar. Today's webinar is going to be covering condominium basics, and we will be presenting our Intro to Condo course, which is a course that we hold every year, and it's really geared to anyone who is interested in condos, whether you're an owner, a tenant, a director, a potential owner, or if you work with condos in any capacity. The goal of today's webinar is to give you a good foundation of what condos are that will help you understand how condos work and things you need to think about if you're going to live in a condo or be a director. If you are a condo director, this course is an excellent introduction and foundation course, which builds on the mandatory CAO course that all directors must take. And in this course, one of the unique opportunities you will have is to ask questions of our panelists who are all experts in condominiums. And you can put your questions in the Q&A box. And we will try and get to all of those questions today. We do have 2 Q&A time periods to try and tackle these questions. And if we have some time, we might also take some questions live. But if you want to make sure that your questions get answered, please put them in the Q&A box. And we'll be going through those questions during one of our Q&A time periods. If you are a property manager in Ontario and you're watching this webinar today live and you want to claim your CPE credits for the CMRAO, then all you need to do is make sure you put your first and last name, as well as the name of your company in the chat box. Don't put it in the Q&A box, put it in the chat box, and that will confirm your attendance at the webinar. Then all you need to do is self-report this webinar on your CMRAO website account, and then you'll get credit for the webinar. And if you are an owner, potential owner, tenant, or anyone else that is wanting to learn about basics of condos and how they work, and you know somebody who may not have been able to attend the webinar that fits into one of these categories, please feel free to share this webinar with them. We will be recording today's webinar and it will be posted on our website as well as our YouTube channel. And I want to take this opportunity right now to thank our sponsors, because without the generous support of our sponsors, we're not able to put these webinars on free of charge for all of you who are attending today. So thank you to Elia Associates, Condominium Lawyers, and Nordic Windows and Doors for sponsoring today's webinar. If you want to find out information about either or both of these sponsors, all you need to go is to our CCI Haronia website, cciharonia.com. And where you would have registered for today's webinar. Excuse me. And then you just need to click on their logos, and that will take you directly to their websites where you can find out more information about each of our sponsors. So thanks again to Elia Associates, Condominium Lawyers, and Nordic Windows and Doors. All right, before we get started, I want to start a poll. And we want to get to know about you and who you are. So I'm going to launch this poll and give everyone 20 seconds to put in their answer, and then we'll see who we have in our audience. Right, and the question is getting to know you. Are you a property manager, condo owner, condo tenant, professional working with condos, a person thinking of buying a condo, or other? Looks like we have good percentage are property managers and condo owners. We have a couple people thinking of buying a condo. Welcome. This will be a great information session for you. All right, I'm going to close the poll in 5 seconds. All right, I'm going to share the results. So it looks like the majority of the people that are attending today are property managers. Followed by condo owners. And as I said, one person who's thinking about buying a condo. So it's interesting to know who's watching our webinars, and hopefully we'll be able to gear our presentation specifically to those people. Before we get started with the course, I just want to take a moment to tell you about CCI Huronia. Just in case you don't know who we are the Canadian Condominium Institute, and we are an independent nonprofit organization that was formed in 1982. We have chapters across the country, 8 in Ontario alone, and CCI Huronia is one of the Ontario chapters. We are also a multiple-time winner of the Lorne Chapter of the Year Award for Tier 1. CCI's main objective is education. However, we also advocate for condos, and we represent all those involved in condos, from owners to directors to professionals, and we encourage all these stakeholders to work together. If you're not a member of CCI Huronia or of CCI, one of our other chapters, it's very easy to join, and you can just go to our website and join directly on our website. And again, our website is ccihuronia.com, and there's a link in the chat box where you can go directly to the website to register. Also, on our website, you can always register for our upcoming courses under the Events tab, and you can access the National Resource Center as well as our Condo Buzz newsletter. Also, don't forget to follow CCI on LinkedIn and on Facebook, and you can also watch all of our webinars on the our YouTube channel. And if you haven't subscribed to our YouTube channel, please do so. That will let you know when recordings have been posted. And as I indicated today, today's recording will be posted in the next 7 to 10 days. And just a disclaimer, just a reminder that the information in today's webinar is current as of today, January 29th, 2025. And the information being provided is general information and may not apply to your specific fact situation. So if you're a condo director and you want to use the protection of Section 37 of the Act, you do need to get an opinion about your specific fact situation from your own professionals. And any reference to legislation in today's webinar is reference to Ontario legislation. All right, so let's get started. And I apologize for the cough. I'm just getting over an illness that is not wanting to leave, but I'm going to motor on through tonight. And we're going to start off our discussion with Ashley Winberg, who is also a condominium lawyer and a member of our board of directors. And she's going to talk about what is a condo. So if you just give me one sec, Ashley, I'll get...
Sorry, Sonja, is that not my
No, you're doing, Evan, you're doing types of condos.
Oh, my apologies.
Hi, everyone.
All right, you can get started and I'll then
Okay, great.
Share the screen.
All right. So what is a condominium? A condominium corporation is a legal entity. It is created when its declaration and description are registered in the Land Titles Office, Land Registry Office. And when a condo's declaration and description are registered, the condominium corporation becomes a legal entity, and the property that it consists of is divided into units and common elements. At that same time, if someone was a purchaser prior to the condo being created, that purchaser would become the owner of the unit that they purchased, with title being transferred to them. And the individual purchasers would also become owners in common of the common elements, with each owner's interest being set out in the corporation's declaration, their percentage in which they own the common elements. Units can be all different kinds. There can be residential dwelling units, commercial, industrial. There can be mixed residential and commercial units or retail units. There could be locker units, parking units, service units, and communication units. And to determine what forms part of a unit at any condominium, you need to look at the corporation's declaration and description. The description will outline the boundaries of the unit itself, and the declaration will define it in greater detail, but also set out what components form part of the unit as well. One thing that is important to note, that although there can be all different kinds of units, only some units have voting rights, and these are generally just the commercial, industrial, or residential units, often, unless it's a unique situation. Often the parking and locker units in a condo that has other types of units do not have voting rights. The common elements of a condo are essentially everything on the condominium's property that does not form part of the units. And this again is determined by reference to how the units are defined in the corporation's declaration and description. So there are generally two types of common elements. There are what I call like general common elements, which are common elements that are not designated for the exclusive use of one or more units in the corporation's declaration. And these are generally hallways, lobbies, elevators. And then sometimes there can be exclusive use common elements, which are portions of the common elements that are designated for the exclusive use of one or more units. And these tend to be rear yards, backyards, driveways, patios, decks, things of that nature, sometimes parking spaces. In addition to having units and common elements, corporations, condominium corporations also have assets. And these can include cash, investments, potentially a superintendent unit, sometimes storage and parking units, and equipment and vehicles. Some condominiums, a lot in the region, have shared facilities. So these can be the portions of the property or particular assets that are shared by a condominium and another legal entity. It can be another corporation, it can be an adjacent property owner, what have you. And these things are generally recreation centers, driveways, visitor parking areas, sometimes service units or communication units. And when these type of properties and assets are shared, there's often a shared facilities agreement, reciprocal agreement, or a cost sharing agreement that will spell out how they are to be shared and how the costs are to be managed. That is that portion for now. Evan, do you want to take over to speak on what type of condos there are?
I would like to do that. Thanks very much. So there's four major types of condos. The first and what we're most familiar with is the standard condo corporation, and these have units and the common elements. But while that's there are opportunities for the developers to phase that in, or what we call phase condominium corporation. And that allows for the corporation to grow over time. So additional units or additional common elements can be added and amended onto that going as the corporation grows. Once it's completed, once a phase condo is completed, it operates as a standard condominium corporation. The next kind of corporation that we see is the Common Elements Corporation. So this is a little bit different. Sorry, I'm going maybe a bit fast. A little bit different than the others. There are no units in a Common Elements Corporation. Instead, individuals will purchase a poddle or a piece of tied parcels of tied land. So the corporation actually treats these parcels as freehold, and the corporation is 100% common elements. Typically see roads or utilities, your underground services, or your street lamps, as well as parks and different amenity areas. It could be like a ski hill or a docking center. But the major point for this is that there is no ownership there is no units, there's no structure. It's the parcel of tied land that's tied to the corporation. The next would be a vacant land corporation. So vacant land corporations, these are condominiums when at the time of registration, there is no buildings. The buyers purchase the vacant land, and then the units are then built, or the structures are built after the fact. Because there's no land ownership, these can't be common element corporations, because common element corporations have Again, there's no ownership from a corporation to a common elements model, and they can't be leasehold condominiums because in a leasehold condominium, which is the next one, the corporation doesn't own the land. They would lease that from it would be a long-term lease, and typically, sorry, Sonia, for the leasehold condominiums, um, purchases would my apologies there. So the corporation would be on leased land, usually 40 to 99 years, over a long period of time. A lot of times this will make the condo corporations more cost effective because that cost is being amortized over such a long period of time. Um, this is typically done when the land can't be sold or it's not advantageous for the owner of the land to sell, but they want to develop it. And so we can see these governments and churches, universities, where they lease the land to developers for over these long periods of time. Those are the four types of condo corporations, and then with the phase that it's model 5.
All right, thanks, Evan. And now we're going to have Patricia Elia, who is a condominium lawyer and member of our board of directors, talk about director responsibilities. Patricia?
Thanks very much, Sonja. Good evening, everybody. Thanks for making the time for being with us tonight as we do an overview of condominiums. And the Condominium Act is really the driver here. There was nothing until the Condominium Act really decided how we would divide space and create condos. But then, of course, there's another layer. When we look at the Act is really consumer protection legislation designed to protect the rights of owners. And it has many sections that govern how a condominium is going to be run. So when it comes to the board of directors is a group of elected individuals, often chosen from unit owners, and their job is actually to help manage those assets. So under Section 17 of the Act, it talks about the objects of the corporation are to manage the property and assets on behalf of owners. So it's important that every board of directors really become familiar with how the legislation works, its different components, and how everything integrates, because that's also part of the good governance. So the corporation, and boards of directors are really driven by sections 27 to 41 for those of you who are interested in looking at the Act. And there you'll find some of the parameters under which the board of directors have to operate. But as well, you'll see that the board of directors must take steps to ensure that owners and occupiers comply with the documents. So what are the documents? Well, first you got to comply with the Act, and then the deck, the bylaws, and the rules, and sometimes even the concepts within our policies. So Section 119 talks about that obligation and how we have to move forward with that obligation as directors. It's not an option. It is something that must be done. And to those of you who are in the management field, it really falls on you often through your management contracts to help the board execute that. Decisions are also that in certain circumstances, people are misunderstand that not all decisions are subject to owner approval. There are special cases, however, in which we will go to the owners and actually ask them if they agree. But you'll see Section 97 is a really good section to break down some of the delineation of those obligations. Sometimes unit owners think, for example, they'll determine whether or not windows are replaced in a condominium. But often those windows are common element and they fall to the decision making of the board, not unit owners. So these are some of the distinctions that we must understand as boards are executing their function, what falls within their bailiwick and what doesn't. Next slide, please. So that's all part of governance, and governance contextually encompasses when we sit as directors, what are we supposed to do? Now, I've talked about the Act. We need to know it. We need to know the deck, the bylaws, and the rules. We need to rely on our team. But we have a fiduciary duty. So Section 37 of the Act is the section that really breaks down how we are supposed to act as a fiduciary. And a fiduciary is a person who's agreed or has undertaken to act or on behalf of or in the interest of another person in a manner that will affect the interest that the other person has in a legal or practical sense. So, what that really means is we are in a position of trust, and it's not just our personal agendas. We have to look at the interests of the corporation. And it's really the corporation that directors serve and how they have to move the operations forward. But we have to also exercise those duties and functions with care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. And, with the advent of director education, which was not always the case, but in 2017 became part of the legislative framework, which is a great idea. Directors actually were held to now a higher standard. We recognize that directors are lay people, they come from all walks of life, but at the same time, we are now more aware as directors. We have more opportunity for information and education. And that is part of CCI's mandate that we need to educate, and there is a need for education. But this helps us as directors to execute those functions, to work better even with our management teams. Next slide, please. So, another important thing to remember, and it's so easy in this day of technology, but the board is not allowed to transact any business of the corporation except at a meeting of directors at which quorum of the board is present. So, in this world of emails and busy people, it's so easy sometimes for boards to want to make a decision through emails, but it's not a legally binding decision. And that's very important, especially for those of you in the management profession, to appreciate that you need a duly constituted meeting. You'll look to your bylaw number 1, and Sonja's going to talk about the documents in a bit, to actually give you the parameters on how you call that meeting. So it's important that we ensure that we have valid meetings, we have minutes, and that we note exactly what business was transacted. And as you know, it's on a majority of the decision of the board, not unanimity. Next slide, please. Oh, and then as well in the Act, thank you, Sonja, that president and secretary are the only 2 officers that are required to be present on a board and appointed by the directors. Everything else is optional, but these days we see there is a breakdown into different officer positions like treasurer, chief financial reporting officer. You can create a lot of different offices for different purposes. Next slide, please. Thank you. So, good governance. Being proactive is part of the first step to good governance. What does that mean? It goes back to the framework of the Act, the deck, the bylaws, and the rules, and then designing. So how do these all come together? As well, good communication with owners, so incredibly important, because owners need to know it's their investment. But the question is how best to effectively communicate with the group of people, because they don't sit in a board meetings. They're not required to, and they're not actually entitled to, only as guests of the board. So what are the ways that we can do that? Sometimes it's posting of the minutes that are not in camera. Sometimes it's a quarterly newsletter. Sometimes it's a town hall. And it also is the AGM, which is mandatory. We also rely on professionals where appropriate. Section 37 really highlights this, that the Act recognizes that while we as directors have to make prudent decisions, we must rely on other people that have knowledge. And if we do so, if we get those opinions, we go to the lawyers, go to the engineers, go to the accountants, go to property management, all professionals, and get their opinions, then we can rely on those opinions. And if we do so, we will be protected in the event that there is a claim against a director or the board of directors because we followed professional opinions. And then I've mentioned before, familiarity with the constating documents. That's important, and I'm not going to get into that. That is going to be Sonja, I believe, that's going to talk about that. So she'll let you know a little bit more about that. So good corporate governance, think about it, be ahead of the curve. And being a good director, it's really important to know what your scope of authority is and do your homework before you get to a board meeting.
All right, thanks, Patricia, and thanks for that lead into governing documents, which is what I'm going to talk about. And so in condos, and Ashley's kind of mentioned some of them, and Patricia's kind of mentioned some of them. There are some key documents that are really important to how condos are run, and whether you are an owner, a condo director, a property manager, anybody who has some involvement with condos in one way or another, you really need to understand these documents. You need to understand the hierarchy and the importance of them, because they are going to dictate or guide how you are going to handle certain situations and how you're going to make decisions. So in terms of our documents, we have the Condominium Act, which is a piece of provincial legislation. It governs all condos in Ontario. You can get a free copy of the Condo Act online on the eLaws website. And a lot of questions that you may have in terms of how do condos operate, a lot of those questions can be answered by just going to the Act itself. And Patricia gave you a lot of sections of the Act in her presentation that deal with boards of directors and governance, but there's lots of information in that Act. So get familiar with that. The next document that's really important is the declaration. And we've heard that, you've probably heard that word before, but really, if you think about the declaration, it's like the Constitution. In terms of hierarchy, the Act is paramount. The only thing that goes above the Act is the Human Rights Code, and Ashley's going to talk about that a little bit later. But under the Act, in terms of hierarchy, is the declaration. So every condo will have a separate declaration. There may be similarities between condos, but they're not necessarily identical. And that is for your condo, that is the highest document that you will have in terms of the types of documents that govern your condo. Then we have the bylaws and we have rules. And again, in terms of hierarchy, the bylaws are under the declaration. They have to conform with the declaration, can't be opposite to what's in the declaration. The rules have to conform with the bylaws. And then we're going to talk about policies, because a lot of condos have policies, but we have to understand how they work in the whole scheme of things. So let's get into a little bit more detail on the declaration. Some people call it the Articles of Incorporation. Some people call it the Constitution for the condo. In your declaration, you will have information that will tell you how units can be used. So if there are restrictions on the unit use, the declaration will that will be one place where you can look for that. It will also tell you what the boundaries of the unit are. So this is really important because when we get into disputes in condos, a lot of times the first question you have to ask is this a common element or is this a unit? And Ashley was talking a little bit about the difference between the two. But in order to know what a unit is, where the boundaries of the unit are, you have to look to your declaration. And under the Act, by default, anything that's not a unit is a common element. It also gives you the percentage of ownership of your unit. And again, this is another piece of key information. Every unit will be assigned a percentage. That's your percentage of ownership of the common elements. That's the percentage that's going to be applied to the budget when they determine what your common element fees are, your monthly common element fees. So that percentage is a really important number, and you find that in your declaration. And the important thing to remember about declarations is they're not easily changed. You can change them by owners voting in favor of a change, but you need 80 or 90% of owners to do that. And it's actually not a vote. They actually have to sign off on it, which is not an easy task. Anybody who has tried to change a declaration knows that it's a lot of work to get something changed in the declaration, or in limited circumstances, you can get a court order changing them. Now, if we move to bylaws, bylaws are a lot easier to change. In most cases, you need approval of more than 50% of units approving it. There are some situations where you may be able to get away with 50% of, or more than 50% of those in attendance at a meeting. But those are very limited situations. For most cases, you're going to require 50% of owner units to more than 50%, sorry, of unit owners to approve the bylaw in order to change it. And that too sometimes can be very difficult to get. So if you can imagine, it's hard to get 50% of owners to approve a bylaw. It's even harder to get 80 or 90% of owners to change it back. And then the bylaws, you're going to have at least one bylaw, and that's going to be your main governance bylaw, where you're going to have information about how meetings are held, who can be on the board, how many board members, what positions, and sort of the general operating of the condominium. That's what their first bylaw is, but there can be other types of bylaws. You can have a standard unit bylaw, you can have a mediation arbitration bylaw. If you're going to borrow money, you need to have a borrowing bylaw. So there's a variety of different other bylaws that you may have, but every condominium corporation is going to have at least one. Then we move on to the rules. Now, the rules, again, in the hierarchy, they're under the bylaws, which is under the declaration. And so rules, really, again, they're another place where you might want to look to see what you can and can't do within your unit, what you can or can't do on the common elements. And they really sort of govern how people should be behaving in the community, in your specific community. A lot of times they will deal with noise, they will deal with using different facilities that the condominium corporation may have, they will deal with aesthetics. So these could be things like, are you allowed to affix lights to your balcony? Can you put wreaths on your front doors? You may have restrictions on what you can paint, the color of your front doors or garages, depending on what kind of condo you have. In terms of the rules, they're decided by the board of directors, and then they serve notice of the rules on the owners. Owners have an ability within 30 days to requisition a meeting if they don't like the rules. And if the owners don't requisition a meeting, the rules come into effect. So they're much easier to change, and they're much more flexible than the bylaws or the declaration. Now, policies, the important thing to remember about policies, excuse me, is that they're really about procedures. Policies are not where you're going to find the things you can and can't do. And the reason for that is there is no provision in the Condominium Act that allows a corporation to enforce a policy. And so if you are trying to put boundaries on what people can and can't do in the condominium corporation, you need to make sure that that gets into the rules or it gets into the declaration, because if you leave it in a policy, there's no real mechanism to enforce it. But you do have different types of policies. For example, you might have a policy that deals with what happens when somebody's late with their common expenses. Set out the procedure that will be followed. Or you might have a policy in relation to harassment. So policies are there to sort of set out procedures on how people can file complaints, steps that will be taken if certain situations happen. Boards are the ones who will implement the policies and design the policies. Owners do not vote or approve the policies. And I'm going to now pass it off to Ashley Lamb, who is a condo realtor and a member of our board of directors. And she's going to talk about another really important document for condos, and that's status certificates. Ashley?
Thank you, Sonja. So status certificates, they're quite an important legal document that one would normally request if you are purchasing a condominium. So you can review the details of the condominium ahead of time before waiving your conditions and following through with your purchase. There are other reasons to order a status certificate, but that's really the main purpose or the main reason why you would order one. Property management legally has 10 calendar days to prepare the documents for a standard order. The cost is $100, and they will not start preparing the documentation until the full payment has been processed. Now, many property management companies do offer an expedited service, which is between 2 to 5 days, but that will cost more than that $100. Normally about $200, maybe even $300. So you'd want to look into that for committing to which service you want to purchase. The majority of status certificates are ordered online, and most of them are passed along electronically now, which is great. And the items that are included in the status certificate include the legal description of the unit and any owned parking spaces or locker, They will also mention if there is a parking or a locker that is an exclusive use, but they won't have the numbers tied to it because they're not owned. If the owner has any outstanding maintenance fees that they do need to pay, so they'll just see if they're at a zero balance or if there are any outstanding payments. Any special assessments that might be in place or planned or that are planning to be in place. Details of the reserve fund, if there are any judgments against the corporation or if the corporation is suing a unit owner. The unit the number of units that are currently leased in the complex will also be noted in the status certificate, along with a copy of the proof of their condo insurance, as well as the declaration, rules and regulations, bylaws, and budget as well. Now, the status certificate is made up of two parts, the certificate part and the attachments. Now, the responsibility of the board of directors with regard to the status certificate is set out in the bylaws. And the bylaw allows the board to delegate the signing of the certificates. And this is done by a motion at a board meeting. Due to the quick turnaround time, when you order the status certificate, it is usual practice to designate the management company or the person responsible for preparing the status certificate as the signing officer. The person completing the certificate is responsible for the content, and they should, in fact, carry appropriate errors and omissions insurance as well. This certificate should have two signatures, and the board should review the certificate and its attachments annually to ensure that it is complete and correct. Now, lastly, the status certificate is only valid for the date that it is signed, but most residential lawyers are okay with reviewing a status certificate that is a few weeks old, provided it has been ordered and received within the same calendar month. That's pretty much it there, Sonja, I would say, about status certificates.
All right,
Thank you.
and I think it's
Thanks, Ashley. We're going to move on to the next Ashley. Ashley Winberg is coming back, and she's going to be talking about how you can request documents. Ashley?
Hi, everyone. So there are two different types of record categories when discussing a records request. There are core records, which are the corporation's governing documents, declaration, bylaw, rules. Minutes from board meetings and unit owner meetings held within the last 12 months, as well as the current year's fiscal budget. And then there are non-core records, and these include the corporation's reserve fund study, meeting minutes that are beyond that 12-month period, and some additional financial records as well. They can also include, contracts the corporation has entered into with contractors, what have you. So, in order to request a record of a corporation, the requester, in this case, I'm going to presume it's a unit owner, the first step is they have to fill out a mandatory government form. It's a prescribed form, and it's called the Request for Records form. And in that form, they need to indicate whether the record that they are requesting is a core or non-core record, how they want to obtain or see that record, whether they'd like an electronic copy, a paper copy, or whether they just want to examine them in person. And then the corporation, upon receiving it, has to review that request, and the corporation needs to provide a response within 30 days. The response also needs to be provided on a mandatory and prescribed government form, which is called the Board's Response to Request for Records form. On that form, the corporation needs to indicate whether the requester is entitled to the records requested, if redactions need to be made, and the cost of providing the records. if any. And I'll get into that a bit more as I discuss core and non-core records. So if the individual is requesting we'll go discuss a core record, the corporation will provide them with the response. And then sorry, I'm just getting my notes. Here we are. They'll review it, and it's important for the requester to review it and ensure that they are satisfied with the corporation's response. If the corporation didn't respond within that 30-day time period, regardless of whether it is a core or non-core record, the individual could advance the matter to CAT, the tribunal. But if they are satisfied with the response provided, they then submit a response to the corporation. And then the corporation will provide them with the record. If they're looking for an electronic copy of the record and it is a core record, generally, unless redactions need to be made, no charges can be charged. However, if the person's requesting a paper copy of it, the condominium corporations are entitled to charge set fees, and then those amounts are delineated by the Act. Upon the corporation then providing the individual with the records, if anything needs to be redacted, because there are certain records or information that a corporation is not permitted to disclose, and that relates to information about individual unit owners, individual units, matters that are currently the subject matter of litigation or contemplated litigation. When a corporation provides those records and they do the redactions, technically each redaction, it needs to contain a note as to why the redaction is being made. For non-core records, let me get my notes here, sorry. For non-core records, upon the responder receiving the corporation's or board's response, they again should examine it and make sure it's satisfactory. And then if they want to receive the record, they would then respond to the corporation to notify the corporation, and that would have to be done within 60 days. And then the corporation has then 30 days to provide them with the record, provided that they submitted the requested funds, if funds are needed in order to produce the record in the required format, or in order to make particular redactions. And then if the requester submitted, let's say more or less than the amount originally anticipated by the corporation can request that the requester pay more if they haven't paid a sufficient amount as anticipated. I always get very confused between the two different ways in which the corporations are to respond to these once they submit the board's request to the unit owner. But it is very important that corporations be very mindful of the timelines, particularly that first 30 days, because if a corporation does not, there are strict fines, and it can become the subject matter of a CAT application, which is now much easier for unit owners to commence on their own without the assistance of legal counsel. So it's important to keep in mind that first 30-day timeline and to reach out to legal counsel or your property manager to ensure that you're adhering to the timeline and redacting everything that needs to be redacted.
Thanks, Ashley. And you'll see on the slide there's the website link to the Condominium Authority of Ontario, which is where you get all the mandatory forms that Ashley was referencing, as well as any other mandatory forms that you need to use in relation to condos. All right, so we're now going to move on to, oops, what happened here? We're going to move on to our first Q&A session. So we are going to go through the questions that people have posted in the Q&A box. Just remind everybody, please get them into the Q&A box, not in the chat. The chat is ongoing and your question will get lost in the chat, but if you get into the Q&A box, we can make sure we answer it. So let's start with our questions. And the first question that we have is just wondering about other condo complexes to see if anyone is getting a break on their, I guess, their contracts for snow removal. We pay the same mill rate as other residential owners, and they receive no snow removal as part of their taxes, but we have to pay extra. So this is a question that we get quite often in terms of sort of double taxation when it comes to condos. And I'm going to pass this on to Patricia, who is the chair of our government relations committee for our chapter. And Patricia, do you have some thoughts on this?
Sure, absolutely. Yes, this is one of the things that we are concerned about at CCI. There is no real mechanism to address that. But what CCI has done in other chapters, which we've been contemplating here in Huronia as well, is how to actually connect with the provincial government and obtain a reduction where we take on some of the duties of the municipality. So that's been successful in the Golden Horseshoe chapter in reducing taxes and acknowledging then that you're getting, you're doing the garbage and recycling. You may be doing some other things that would be usually in the municipality's bailiwick. But right now there's no prohibition and there's nothing stopping that dynamic from occurring. So to the extent that you know somebody in the legislature, you know somebody at MPAC, let them know and talk to them and we can start the dialogue.
All right. So it's really about negotiating with the
Mhm.
municipalities to be able to get a break on
Yeah.
that. And some condos have had success, right?
Yeah, absolutely.
And
Absolutely.
some condos are still struggling to get that sort of equality. All right, next question. Our board makes it hard for non-members to be aware of what's going on. What can be done? So I assume this is an owner speaking, wanting to know how do we find out what's happening at the board. Ashley Winberg, do you want to take that question?
What you could, you can ask for record requests. You can submit a request for records in order to see copies of the board meeting minutes. But you'd have to do that each and every time. I would suggest that maybe you reach out to your property manager or your board to see if you could be invited to attend one of the board meetings and potentially suggest heading up a communications committee. Oftentimes, your manager and your board, they're volunteers. They have a lot of things to attend to, and it's difficult to always communicate what they're doing to everyone. But you might want to reach out to them to see if they would welcome some volunteers to help with spreading that message.
Okay, and sort of a follow-up to that question, somebody was asking, do other condos circulate board of director minutes on a regular basis? So Patricia, what would be your experience with the boards that you work with? Do they usually plan on circulating board minutes or
Yeah.
not?
Some of them do. I wouldn't say it's the majority. And I think one of the tools that has really helped a lot of boards is that now a lot of them have websites where they can actually post documents. They'll put the constating documents, they'll put some the minutes and maybe financial information, which, sort of saves both sides of the equation. There's not a records request required. There's easy access for everybody. So if when they have those kind of platforms, I've seen a more of a willingness to put non-in-camera minutes up on the website so people can see what the board has done every month.
All right. And Ashley Winberg, what's your experience working with boards? Do most of them circulate them or not?
It's very similar to Patricia's. The technology has definitely made it much easier to do so, but it really depends on whether or not, the unit owners are the type that would benefit from that type of service. So it's a yes, no, it just depends on the community and the level of transparency that the board wants to provide.
And I
And how
think
much
I
time
just
you have to do it.
And I would just add to that, I think you have to be careful when you're circulating minutes because there's certain types of information that other owners are not entitled to. For example, information about other units. And if you look at section 55, 4, it tells you what information unit owners are not entitled to. So if you're going to circulate minutes, you need to keep in mind those restrictions. And so you might end up having to redact minutes, where sometimes that actually prompts more problems when you circulate redacted minutes. So give some thought to whether or not there is value in circulating it. Another way to do it is to do a synopsis, sort of just a board report where you're passing on information that's generally applicable to the condominium corporation, but you're not discussing any specific units. Okay, Ashley Lamb, there's a question about status certificates. And the question is, do all units receive a status certificate when first purchased?
Yes, if someone pays for it. It's not for free. So what I've always done is if you're purchasing a condo and you don't want to have it as a condition for your lawyer to review, you can have a clause in there stating that the seller will pay for a status certificate and it will get delivered to the purchaser prior to closing so that you actually do have a copy of that and you're not actually paying for it. Now, if you don't do that, then after you take ownership, you can definitely request, but you would have to pay.
All right. Okay, so does everybody get it? No. Should you get it? Probably yes. There's a lot of
You
information
should.
in that status certificate that you were going to want to know if you are purchasing. And what are your thoughts? Anybody on the panel can jump in. What are your thoughts on the purchaser buying the status certificate versus relying on something that the seller has provided or the seller's agent has provided? Anybody have thoughts on that? Jump in.
I think the purchaser should get their document directly from the corporation and have their counsel review it. I mean, it's very nice of a vendor to do that, but you want your copy straight from the condo, I think, and in your control.
And you'd also want it to be
No, go ahead. Go ahead. Sorry.
as up to date as possible, because the status certificate, the information in it is only valid to the date that the status certificate is issued and signed. So a more recent one is recommended.
Right.
Yeah, and you make a good point there because there is a couple times I've actually suggested this to buyers of mine. If they have a really long closing, if it's a 6-month closing or a 5-month closing, you might actually have the offer conditional upon your lawyer reviewing the condominium documentation. But if you don't close for another 6 months, a lot can happen in that time. So it would be good to get an updated status certificate. It's only $100, definitely well worth, even if the purchaser pays for it themselves, reviewing everything and making sure that you know what you're getting yourself into for sure.
All right, here's an interesting question. What percentage of owners is required to change the property management company? So if you recall when I talked about governing documents, I talked about bylaws, declarations, rules, policies. I did not talk about property management company contracts. So Patricia, do you want to take this one? What's the percentage of owners that are required to change a property management contract?
I like these trick questions. It's 0%, and it's because the board, in managing the assets of the corporation and its operations, really makes the decisions about the management company and the terms of the agreement. All of that lies with the board of directors for any supply contract.
Okay, so if you go back to Patricia's presentation on board of directors and governance, right? There are certain decisions that are in the hands of the board that owners don't get a say on. And you have to remember as an owner, when you elect a board, you are passing on the responsibility for decisions that affect you to the board. And if you don't like the way the board's making decisions, you do have an option to requisition a meeting to remove the board, but otherwise you need to sort of accept those decisions. John's got his hand up.
I was just going to, I wonder if the spirit of the question was more a case of can you requisition a meeting to discuss the management contract and potentially, direct the board to change managers. And I think that is a 15% to get the meeting and then a majority vote.
If
Yeah.
you want to have a discussion about it, absolutely, you can have a discussion through a requisition and ask the board about it. But sometimes the requisition can also be not accepted if the board doesn't want to talk about it because they don't have an obligation to talk about it. So sometimes you see things that come across on a requisition that are not really validly within the scope of a requisition. So it depends on how the board would like to handle a request like that. Generally, though, I have no problem talking to owners and hearing what they have to say. I recommend it for boards. If they've taken the time to do a requisition, they care about something. So it's just creating the right sort of expectations around that kind of forum if the board decides to do something like that. But that's a good take, John. I think that's important to consider.
But I think if we go back to the question is what is the percentage required to change? And the
Mhm.
percentage, it can't be changed by owners. Owners can't decide on the property management contract. The board, that's a board decision. The
Mhm.
owners can decide on who's on the board. They just can't decide that specific question. All right, we have another status certificate question. So I'm going to post this question to both Ashleys. Whoever can jump in first to get it, go for it. It says status certificate is only valid for 30 days. True or false? Is that right?
It's false. It's technically only valid for the day that it's been signed, technically. Um,
Ashley,
The
what?
but
invitation is
some lawyers, if they're reviewing it, they will be okay. Like, let's say it's dated on the 10th and they're reviewing it on the 20th of the month. The main thing here is the fact that they want to make sure that the unit owner's maintenance fees are all paid up for that month. So if it's within this same month, they might be okay with not having an updated certificate. That's probably why some people think that 30 days it's valid for 30 days, which is not really true.
Ashley
I
Winberg?
don't know. Ashley, if you
Yeah,
have
the
anything
information is valid as of the date that it's issued. So
yeah.
the sooner the better. I think maybe depending if your lawyer who's helping you close the deal is a lawyer that primarily does real estate transaction or a condo lawyer that disputes these things on behalf of corporations, people may have a different interpretation, but it's valid as of the day that it is issued, in my opinion.
Yeah, exactly.
Okay, quick question here. Can we remove the entire board at the same time by requisitioning a meeting of owners? The short answer is yes, you can. But I'm going to put a hold on requisition meeting questions because we could spend the whole night talking about requisitions. And if you're interested in learning more about requisition meetings, we are actually doing a webinar on February 21st called The Ins and Outs of Requisition Meetings. So if you want any more information about requisitions and how they happen and what you need to think about, be sure to join us on our webinar on February 21st. And you can register for that webinar free of charge by going to our website and clicking on the events tab. All right, a couple more questions, and then we're going to go back to the second half of our presentation. And then we have another question period at the end. Hopefully we'll have time and we'll try to get to some of those other questions. Here's an important question I think we need to cover. Can we count owners' votes who are absent at the duly called meeting of owners to pass the borrowing bylaw? All right, Patricia.
Well, if an owner is absent, they have an option to use a proxy. And so what that means is they can appoint somebody to exercise their votes, but using the prescribed form, they can also cast their vote and direct their proxy how to cast their vote. But also now with the advent of electronic voting, pre-balloting is now legal. So if you want to cast your vote because you know you won't be there, you can do that. So there is a way to capture it, but that's the only way to count an owner that is absent, is that they've actually in some way indicated their vote through one of the methods that is legal to do so. Otherwise, we would be guessing on, how they voted on a bylaw. And, as Sonja mentioned, there are some critical threshold considerations.
All right. Okay, so let's continue on with our presentation. And Patricia, you are up because you're going to be talking about unit owner meetings.
All right, thank you. Very exciting topic. I think that unit owner meetings are a vital component to the Act. And Section 45 begins off that section on owners, but talks about meetings. And so unit owner meetings, there are mandatory versus voluntary meetings. The mandatory one that you'll see referenced in Section 45 is the annual general meeting. And the board is required to hold that annual general meeting, not at a new condo, but at a regular established condo 6 months after the end of each fiscal year. Why is that? Well, we want to make sure that we are accountable to our owners, that we are giving them relatively timely information on their financials. It does take time to collate audited financial statements and do that work. And as well, we cover other material business at these annual general meetings, such as the election of directors, and the approval of minutes from the last AGM, for example. There's also information meetings. Now, those are not mandatory. There's no requirement to meet any of the notice requirements for information meetings, also called town hall meetings. So those are voluntary. And why do we do those? Well, because we know that there's something afoot in the community. For example, a big project is coming up. We want to explain to owners how it's going to work. We want to talk about, for example, the management contract, but we're not going to have a vote on it. We think it's an important topic to discuss, so we talk about that. We talk about things that are of importance at that moment for unit owners. Sometimes as well, boards will also hold information meetings throughout the fiscal year or the calendar year um, to lead up to the AGM so that people are not in the dark for the other parts of the year. Then there are requisition meetings, and requisition meetings we've talked a little bit about. Requisition meetings are pursuant to Section 46, and they really have a very definitive process. You have to use the prescribed form to requisition a meeting, but you have to obtain the approval of a minimum of 15% of the owners to hold that meeting. And the requisition has to be in writing, signed by the requisitionist, state the nature of the business to be presented at the meeting, and be delivered personally or by registered mail to the president or secretary of the board or deposited at the address of service. It can also be that you're requisitioning the removal of directors. And you'll see when you look at the form, there's a very specific section that has to be completed. So I would definitely recommend when you're doing a requisition, follow the boxes, understand and also think about your expectations with a requisition meeting so that the requisition is valid if important information is to be covered. So can we go to the next slide, Sonja, please? So with unit owner meetings, the expectations should be to communicate, engage, and respect everybody in the room. And often, the chair and Ashley, Sonja, myself, we often ask to chair these kinds of meetings. And we set the tone. The chair sets the tone for these meetings, and they have a very specific role. One of the other expectations is that the meeting should be objective, I think, and feel that people should feel no matter which side of the coin you're on of the issues, that the chair has handled the meeting fairly and in a reasonable manner. With respect to the annual general meeting, and if we could have the next slide, it's really important to get the timing right. And with the changes to the Act in 2017, what came about was the pre-notice or the preliminary notice component. And what you need is at least 20 days before you have to send out the notice, you have to send out pre-notice, okay, for the annual general meeting. And you have to give a time frame for unit owners to respond to the content of the prelim notice. And what that is for the AGM, you could sometimes suggest that we would like to change the auditor. You can indicate that to the board. You can also ask them to include material on your behalf. For example, you've gone and received, 3 quotes from other auditors that you think could do a good job. And you can put those in the package and that would go out with the notice. Now the board has some discretion here when you're sending out those packages and what they'll include. They may choose not to include things that are offensive or not applicable to the issues on the agenda for the AGM, for example. But then once you get to day 21 in our diagram, you can see it there. You have to send out the notice for the meeting. And the notice, again, is also a prescribed form like the pre-notice. You have to complete it, and if it has to have at least 15 clear days, which really means clear, when I'm being cautious, I say it's 17 days in total just to be safe. But when you actually want to calculate the dates, for those of you who are managers, you have to look at the Interpretation Act and how actually we count days and what are considered days and how statutory holidays may be also considered in the count. So be careful, give yourself enough time, think about it, plan ahead, make sure all your people that you need at that meeting, for example, the auditor, often the most important person at that meeting, is there, and that they can present, for example, the financial statements, because the auditor represents the unit owners, not the board. So the unit owners have an expectation that the auditor will be there to present, and they have a right to be there. So these are some of the approaches and the considerations when you're holding meetings. And now I'll turn it back to Sonja.
Thanks, Patricia. And now we're going to have John Juffs talk to us about the difference between self-management and having property management. And John has been busy answering questions in the Q&A and on the chat box, and he is a member of our CCI Huronia Board of Directors, and he's also going to be talking to us about reserve funds a little bit later, which is his area of expertise. So John, can you fill us in on the difference between property management and self-management in less than 5 minutes?
I'll try my best. So condominium corporations have become a very complex entity, really since 2017 in particular, but since 2001 when the act was brought into force, and it's been modified many times since. And the complexities, speak to the profession of property management taking, a primary role in making sure all of the, day in and day out operations of the corporation are looked after properly. But it's not a requirement of the act. Some corporations are able to manage themselves quite aptly and quite succinctly. And so that, comes with its challenges. You got to meet all these deadlines and make sure proper notice is given and things like that. And if I would suggest that probably smaller corporations are able to do this because, it's easy to drop off 6 notices to a meeting, or even sometimes get all 6 people at a meeting and have them agree that then sufficient notice was given. But when it comes to property management itself, you can either hire an individual to be an employee of the corporation, and that comes with all of its attendant problems. Obviously, you want a good, solid employment contract in place, and you will be responsible for all the things that go along with having an employee. And that probably just adds complexity that the board was trying to get away from. And so more commonly, we see management firms being hired by condominium corporations. And this helps because most management firms have many licensed managers. And so if somebody is sick for a few days, or if there's, a conflict between the way the board manages things and the way the manager sees things, maybe that conflict can be resolved by a new person stepping in instead. And, there's a lot of benefits to that. And so those are really the 3 nuances as you see on the screen there. Self-management, so no hiring of anybody. The board does everything themselves. A direct hire, employ somebody, which, comes with all of the problems that go with it. And professional management company, which would be governed by a professional services contract with, things like termination clauses and payment requirements and things like that. I think the most important thing, though, is that anybody doing that management has to be licensed. And this has been such a tremendous boon to the condominiums in Ontario because they're now skilled people who have received the mandatory training and are monitored regularly. And most of you here tonight are managers getting your continuing education credits. And so we thank you for it. The other thing to bear in mind is, most professional management firms have, on-call emergency services and the ability to react quickly to emergencies that might happen. They always happen at the most inconvenient times, either in the middle of the night or on a long weekend, or both. And so it's important that you have that ability to react to important things for the condominium corporation, and usually management companies are well equipped to do that. They can also help you find, economies of scale and hiring other services, like janitorial services, snow cleaning services, landscaping services, things like that, which can be beneficial because they do it day in and day out for a living. Not to preclude that self-management companies can, or self-managed condominium corporations can do all of those things too. And what we often see in them, and in CCI Haronia, we do have a significant number of self-managed corporations. We often see that there's, a president for life type person that is always, helping get things done and has the telephone number of the guy to call and that sort of thing. So these are different approaches that are important, and it's really about how involved the condo board can be and to keep the community running smoothly and happily. And so those my less than 5 minutes take on property management.
All right, John, thank you. So when deciding whether you want to do self-management or you want to hire someone, we're going to now switch over to Patricia, who's going to talk about all the stuff that has to be planned sort of on an annual basis, and that might help you decide which one of these options you are going to pick. So Patricia, you want to talk about the annual plan?
Sure, no problem. I think one of the things you have to step back and look at is that all condominiums, run on an annual calendar. So you really need to think your year in advance and think ahead on what needs to be done. The annual budget needs to be done, as well as reports to owners and yearly contract renewals. The fiscal year end is usually related to the original date of registration. So that's random and arbitrary in the calendar year, but a lot we see December, March, all the way up to June. It can be very busy with AGMs. But the best practice for a board of directors is to develop an annual plan that sets out the expectations contained in the budget and pinpoints when the work will be done. So I think there was a question in the chat about, like, what do we expect? Well, we need to think about board meeting dates. And so when can we discuss things? Contract renewal dates, like what's coming up and what needs termination. So this is really important. Some contracts require 60, 90, 1 year in advance termination. You need to know if you're going to renew them or you're going to terminate them, for example. Get all your information and pricing in advance if you're thinking of switching. AGM date, you need to think in advance because, as I mentioned, there are other people that have to show up to do that. Routine notices, like how are you going to do the actual notices that go with the, for example, capital asset projects? So you need to make sure, for example, if you're self-managed, you tell people that there's a window replacement project, but what does that mean? How does that impact? So these are all the things that a board needs to look ahead to doing. And, when we have professional managers that are experienced in this, they actually use a lot of tools to help them plan and organize the sequencing of all the things that the board needs to do. In addition, you also have to create your monthly packages, review the financials, look at lien processes. For example, you have to make sure that you don't miss your lien rights if people are in arrears. So who's managing the timing? Because if you don't register within 90 days from the date that the arrears arise, you've lost your lien right. That's not protecting the corp. So there's a lot that goes into the annual plan, and it's better to sort of think about as well, how it's all going to fit together, what the policies and processes will be, so that you can implement effectively.
All right, thanks, Patricia. And now we're going to move on to a hot topic in condos always, and that's money. And we have Blair Spinney with us, who is an auditor and works with a lot of condominium corporations doing their audits. He's also a member of our board of directors and our treasurer. And Blair, I'm going to ask you to try and go through this section in 5 minutes if you can, because we are running out of time.
Yeah, sorry, I gotta take my 10. No. So let's first of all let's talk about the community of condominiums. So you're a condominium, you're in a community, and community living really requires a process be followed to operate and maintain the assets and common elements, and ensure there's sufficient finances for the operations, as well as current and future major repairs and replacements. So the first step in dealing with money is how much do we have to collect from the owners? And that's done by setting up a budget. So the budget is done annually, and it doesn't require the vote of the owners. It's done by the board or approved by the board. So the budget includes a budget for the line items and operations, as well as the allocation for the reserve fund. And so the reserve fund is the next topic. So John will be covering that. So once we have our budget and the amounts that the owners are going to pay, the industry standard is that the owners pay by pre-authorized payments. So we're using technology here to prevent fraud and error and to save time. And you can use post-dated checks, but that's again more work and less control. Cash should never be accepted for anything. The other thing to cover is what happens if you don't collect the money. So if an owner defaults, the corporation has the right to register a lien against the owner's property unit. And that's a powerful way to enforce collection, as you will have super priority over other debtors. So now we'll say we've got the money. What do we do with it? Okay, under the Condominium Act, the corporation is required to maintain at least one bank account for operations and one for the reserve fund. So the common element assessments should be collected on the first day of the month and deposited into the operating account, and a transfer for the reserve fund portion of this payment should be made the following day. Okay, so now we've got our money in our bank accounts, check signing. To ensure timely utility payments, most corporations use the pre-authorized payments. For other items, now I guess this is dealing with checks. You're generally have two signing authorities, and this can be done online without checks. This is becoming more and more common. Again, this saves time. And it also gives you more opportunity to have controls. So when you've got two signing authorities, the more you can involve the board of directors, the better. The more, because that just increases the oversight over what's being done. And of course, it's self-managed. You have no other choice, but you're going to have two directors. But like I say, the more involvement that the directors have, the better. The next item is the financial statements. So now that we've collected the money and paid the bills, the financial statements are usually prepared monthly by the management company, and all board members should receive a copy of the statements, and at minimum, the statement should include the balance sheet, income statement, and a reserve fund statement, the arrears schedules for any receivables, and the bank reconciliations for the operating and reserve bank accounts. So these are the internal financial statements. The external financial statements are general purpose financial statements for the owners and potential owners. So these are going to people that generally don't have the access or knowledge concerning finances that management and that a director would have. So these statements give more information about uncertainty, information about estimates, contingencies, and risk. They give more information about future cash flows, like information on commitments and details on loans. They also talk about related party transactions. So there's a presumption that all of the transactions the corporations is taking part in are at arm's length, two separate parties with no other relations. So in other words, if a director is using his company to do some of the repairs, that should be disclosed. And there may be questions about how these types of relationships are managed and what kind of controls are in place. Generally, if there's 25 or more units in a corporation, these statements should be audited. That's a requirement under the Act. And the auditor, as previously mentioned, is appointed by the auditor, or is appointed by the owners, and is the only contractor that is appointed by the owner. So that's important to be involved in your AGMs. That's it. 6 minutes.
All right, thanks, Blair. All right, we're going to do a very quick overview of reserve funds. We are having a director certificate program coming up in April that is going to focus on reserve funds exclusively. So, John, just give us an overview for today, and anybody that's interested in joining us for the director certificate course on reserve funds, you can find information on our website under the events tab. So, John, you're muted.
That was my best line too. There's 3 jars on the screen because I can do this in 3 minutes. When it comes to reserve funds, there's 3 things to remember. You need a fund, as Blair said, a bank account that has reserve funds in it. You need a study, and the study is done by an independent person, and they have to be of prescribed class, typically engineers, architects, and so on. And you need a plan for future funding. So what happens is we, as reserve fund planners, lay out all the costs over a long period of time, a minimum of 30 years, and then we create a funding plan that makes sure you never go into a negative balance, or hopefully have just a reasonably low balance that you're never down to zero. And you get that sorted out, and that goes to your reserve fund line in your budget, and that's how much you set aside in the reserve fund, and then you pay for major repairs and replacements of the common elements from that fund. And there you go. That's the Cole's notes.
All right, thanks, John. And the major words to pay attention to is major repair and replacement of common elements and assets. Only reason you can use a reserve fund, right?
Correct. That's the only way you could use the reserve fund.
Okay, thanks. All right, another topic that we always get lots of questions on, and we're going to be doing a webinar in May on, which is insurance. And Patricia, you're going to give us an overview of some of the things we need to think about for insurance when it comes to condos.
Sure. Well, insurance, it's mandatory, and Section 99 to 105 are your sections that you should look at. And really, when you look at insurance, common elements and the units are covered by the insurance. And that's one thing that's very important to understand about these policies that are mandatory if they're available. But also, we have a standard unit that is implied to exist under the Act. But what the standard unit does is that in the event of an insurable loss, it sets the standard for replacement. So that leads to the next point, which is that anything outside of the standard unit is excluded because it's considered an improvement in the unit and therefore will not be covered by the corporation's policy. Unit owners should have their own policies. And there's some good policies out there that cover betterments or improvements, as we call them in the industry. And so I would strongly suggest that for you that are in the property management industry, when you look at the declarations, you'll see that it confirms that the corporation has to have policies in place for insurance purposes, but that unit owners are not mandatorily required to do the same. Therefore, it's important that boards and management teams work together to encourage unit owners to buy insurance if it makes sense in the situation. So looking at the standard unit bylaw and the other betterments, improvements that could exist, giving unit owners the heads up. I think that's it for insurance, Sonja.
All right, thanks, Patricia. Okay, next topic I'm going to cover, and that's enforcement. And as Patricia talked about at the very, very beginning of the webinar when she talked about governance, one of the jobs of the board of directors is to take reasonable steps to enforce the rules of the condo. So those rules can be found in the act, in the declaration, in your bylaws, and your rules. But one of your jobs, and it's an unfortunate job, is you got to enforce. And so what we like to start off with when we talk about enforcement is to remind everybody that enforcement starts off with communication and proactive communication. And a lot of people rush through this initial step, and it ends up costing corporations and owners a ton of money. So it's really important at the beginning that if somebody's breaking the rule, that you take the time to communicate with them proactively and educate them on what the rule is. Most owners do not know what the rules are. They get their status certificates, they get the rules and the declaration attached to the status certificates, and they don't read them. All right. Ask yourself how many of you have read your status certificates. So the best thing to do as a first step is if somebody's breaching a rule, make them aware of what the rule is, let them know what they need to do to become compliant, and hopefully that solves the problem. If it doesn't, then you're left with a couple options. And depending on what the issue is, you might be going to mediation and arbitration. There is certain things that have to go to mediation and arbitration. You can't go to court. You can't go to CAT, which is the condominium tribunal. You have to go to mediation and arbitration. That's a private process. But that's, one way to deal with enforcement. Another way to deal with enforcement is to go to the courts. And again, limited things can go to the court. And then, oh, sorry, didn't mean to do that. Then if you can't go to court, if it's not subject to mediation and arbitration, then you are going to the CAT. And the CAT is the Condominium Authority Tribunal. And that is part of the CAO. And it's a tribunal that decides issues with respect to records requests. They decide issues with respect to nuisance, different types of nuisances. There's some talk, if you are following what's happening in the news, there is some talk about expanding their jurisdiction to include some other things. So CAT has very limited jurisdiction. Certain types of disputes have to go to the CAT. And then at the end of the day, when it comes to enforcement, the biggest thing you have to make sure you understand is which venue you're going to go to. And that's where you're probably going to want to get some advice from your condo lawyer about how you enforce the rules when owners are not wanting to do so voluntarily. All right. And our last section that we're going to talk about, and Ashley, you've got like 2 minutes to do it, is just a brief overview of some of the other laws that we haven't talked about yet and how they affect condos. Ashley?
There are a variety of different laws. For employment and labor relations, there's the Employment Standards Act, which pertains to employees of condominium corporations, as well as the Labor Relations Act. Some cleaning and superintendent staff at condominium corporations are unionized, so that is how that particular piece of legislation would apply. There's also the Occupational Health and Safety Act, the Occupiers Liability Act, because all condominium corporations are the occupiers of the common elements for liability purposes. There's a lot of municipal short-term and rental bylaws, particularly there's some in Collingwood. And each municipality has their own bylaws, so take a look at your municipality's website for those because they are specific. And more generally, for condominiums throughout Ontario, there's the New Home Warranties Plan Act carry on about construction deficiencies. The Condominium Management Services Act, which regulates the condominium management profession. And as Sonja mentioned at the beginning of the webinar, there's the Human Rights Code, which trumps the Condominium Act if the corporation is required to provide accommodation up to the point of undue hardship. And a hot topic in a lot of condominiums these days is privacy. So the various pieces of privacy legislation can be used as guidelines for condominiums. They do apply to some management companies depending on their jurisdiction. So that's, I think, as quickly as I could get through all of those. But there's a variety of different pieces of legislation because many condominiums are property owners as well as employers. So just take a look at your local websites, particularly with respect to short-term rentals. You'll see them on your municipality's website.
All right. Thanks, Ashley. The purpose of that slide is just to make you aware that it's not just the Condominium Act that applies to condos. There's a ton of other legislation that also impacts condos and condo living. And so it's really important that you have advisors who are able to understand how that all interacts. All right. Well, we're at 8 o'clock and the webinar is supposed to finish at 8 o'clock, but we do have some questions in our Q&A. So what I'm going to say at this point in time is if you can hang around, we'll hang around and answer some of these questions. Up on the slide, you'll see upcoming events that we are hosting. We have our Lunch and Learn webinar series As I've already told you, February 21st, we have the ins and outs of requisition meetings. In March, we're talking about navigating the current economic climate. In April, we're talking about condo security. In May, we're talking about insurance. And as I mentioned when John was talking, we are having our Director Certificate Program, Reserve Fund Fundamentals, on April 16th. These are all available via Zoom, and you can go to our website and click on the events tab to register for any of these events. So let's get to some of these questions. There was a question, and John, I think you were starting to write an answer. It was, can we add an item to the reserve fund study later if required? Do you want to just let everybody know what the quick answer to that is?
Yeah, so not really. The reserve fund studies for existing common elements and their major repair or replacement. Now, it may not be that it needs to be added. It may just need to be fit into one of the categories that the reserve fund study provider delineated in their plan. And so, instead of saying wall repairs, maybe it's brick repairs, wood, painting and, stone repointing to make it more clear as to what's being done to the walls. But the common elements are all covered by the reserve fund. And if something isn't clearly delineated, that doesn't negate it. It's still a common element. Money can still be spent on it, and you just account for it when the next update is done in the plan.
All right, Blair, here's a question for you. Do condo corps have multiple bank accounts, operating reserve expenses that are not yearly, but maybe every 4 years? I don't know if that's a contingency plan, perhaps, that they're thinking about, but what do you see, Blair?
Obviously, there's a requirement to have both the operating and reserve bank accounts. What the corporation can do is, instead of having separate bank accounts, because that's a lot more administration and accounting, is they'll have separate funds. So in other words, you may have one operating bank account, but it can have several funds, a contingency fund, something along those lines, and both of those are using that one bank account. So that's probably the most common way to deal with it. You have set aside funds from the operating fund.
All right. And here's a question. I think Patricia or Ashley jump in. Can a corporation hire a licensed manager who lives in the same building without going through the management company?
Do you want to go first, Patricia?
Yeah, you mean as their manager? I'm thinking that's the assumption.
I assume so,
Okay.
yeah.
Yeah, no, probably because you're not hiring the manager, you're hiring the corporation that hires the manager. So it also depends who holds the license for the management company, because their liability is also engaged. So you'd still have to have a relationship with the company that employs that manager. That's what my take would be on it. Ashley?
Yeah, the person has to be licensed. They'd have to be a general license. They can't be a limited license. And if they do reside at the property, I think that should be disclosed to all residents to ensure that no one has an issue with that. But that can get a bit complicated.
Right.
It might be better not to do that, perhaps.
All right. Here's a question. Can we pass a bylaw that insists on communication with all residents before undertaking huge expenses? Patricia, this comes back to your governance part of the presentation. Do you want to take this one?
Yeah, well, you can't do a bylaw to really direct that, I don't think. I've never seen one. It might be a very good suggestion so people know, but I think the thing is you have to balance out what the other obligations are that the corporation needs to fulfill, including maintenance and repair obligations and the obligation to make sure it gets done. Providing communication is not a bad thing. Don't think you should even need a bylaw to let people know what's coming. Personally, I think you should let them know. But to make it sort of a legal compliance issue that you could take them, I don't know where to enforce, might not be able to be upheld, I think.
All right. Here's a status certificate question. I'll give this to Ashley. If there's a material change after a status certificate has been delivered to a prospective purchaser, is the corp obligated to update the purchaser as to the material change?
If you're asking me, no, they are not. No, it's valid as of the date that it's issued.
All right. Anybody else want to add something to that?
They're not obligated to, but I was involved in a corporation where this actually became quite significant, and it was exactly that, a special assessment announced after the status certificate was delivered to a purchaser. And I think Ashley mentioned that if you have a long closing, you want to get an updated status certificate closer to the date of closing. And so, no, the board's not obligated to. And yes, the purchasers would be wise to pay attention to long closings and get an updated certificate so that they would have been informed about the special assessment that was announced.
Yeah. And I think also on that thread, it's important that boards are really aware that if they have an inkling or they know something, that they really do need to put language in the status certificate that gives enough information to provoke a question by the lawyer for the purchaser. And usually you'll see that somewhere in section 12, where it talks about, do you know about anything that might increase our common expenses? And, then you really start to disclose. And what's interesting is, especially in the period that we've come through where we found that reserve funds are maybe not always matching the price of things, and, certain repairs come up unexpectedly, there are areas where we can give purchasers the heads up, which might even change over like the time from the initial status certificate to the time of closing. And the obligation would have been on the purchaser to update that status certificate prior to closing and see that there may have been an evolution in the status certificate. So, if we're protecting the purchaser, it's really on the purchaser, I think, to do the work.
Yeah, you're reading my mind there, Patricia. I was just going to give that warning to boards and property managers to, even if you don't know the details of what's going to come up in terms of costs, if there's any discussion about expenses that might be coming up and they're big expenses, you want to definitely be giving purchasers the head up. It's your job is not to make those status certificates easy to sell units. Your job is to make sure that purchasers are aware of what's happening or could be happening at the condo that could impact them, impact their decision to purchase. All right, here's another question. What document do you look at if there is no standard unit bylaw in terms of who repairs what after damage? Where do you find that information?
Ashley, do you want to do this one?
For new condominiums, there can be a particular schedule. If there's no standard unit bylaw, you can look there to see what's included, if that exists, what's included as part of the standard unit. But you should be looking to the Condominium Act. The Condominium Act sets out the obligation of the condominium corporation to maintain insurance for major perils, which includes water for both the units and the common elements. So in the case of water and other major perils, the condominium's insurance will always step in first. And then it will really be a subrogation issue between the unit owner's insurance and the condominiums.
All right. And insurance is such a complicated topic. We do have some webinars that are posted in our past webinars where we talk about insurance and how insurance works. So if you are wanting to get some more information or try to understand that complicated world of insurance and condos, you can also check out one of our past webinars. All right. What is the process to discontinue a management contract before the contract term? Patricia?
The terms of the contract. You really have to read them and understand what the termination options are. There's sometimes no termination options unless there's a material breach. So really, if you're navigating that with your boards, make sure it's really clear, what should be in the contract. And typically in the industry, it is a 60-day notice period that you let the management company know that you're switching. But it has to be done in a certain way, but it's all driven by the terms of the contract.
All right. Hey, Blair, here's a financial statement question for you. Can an owner have access to the general ledger, bank statements from the financial statements, or simply can the owner receive a full financial statement package monthly?
I think that's something that they'd have to put in a records request form in for. We just can't, keep giving out all that information. And probably it's possible that parts of that information would have to be redacted as well, if there's receivable lists with unit owners and whatnot. So there would be a lot of work to do that for the management company or the board.
Yeah. I would just add, owners, when you're thinking about making those requests, think about the amount of time and energy that property managers and boards have to put into dealing with those requests and what it is you're really looking for information on. I've seen this, I'm sure Patricia and Ashley can attest to this as well. The amount of money that is spent on sort of what we call fishing expeditions. We want to just see everything, but we don't have a specific reason for seeing those documents. And it's a very expensive process. And at the end of the day, the people that are paying for that expense are all the owners. So when you're requesting records, keep it in mind the fact that there is a cost to that request. And that doesn't mean you're not entitled to make requests for records, but think about when you are making those requests. Okay, a couple more questions and then we're going to wrap it up. Can a management company employee who's also a condo owner be part of the same condo's board and holding a position like president or vice president? All right, so this is a conflict of interest kind of issue. Is that a conflict of interest?
Yes, it would be under Section 40 of the Act. It would be something you have to disclose. But the interesting thing I think with Section 40 is that you disclose it, but it doesn't necessarily mean that you can't be part of the board. And I think that's something people have to think about. Like, what's your conflict of interest policy? But if there are decisions that have to be made, you wouldn't be able to sit in the room. So I think it's important to also delineate like what is your role, even if you're an employee of the management company. Are you the manager, and are you sitting on the board? I mean, it's you've really got to delineate your roles. But there would be at the outset, I think, a perception of conflict. And
Anybody else?
yeah, sorry, go
No,
ahead.
go ahead. I didn't mean to cut you off there. Sorry.
No. I was just saying, you have to manage that perception and make sure that there's no conflict of interest actually affecting decisions.
Anybody else want to add anything into that? I think the only thing that you need to also take a look at are your bylaws, because there might be certain things that would disqualify you under the bylaws, and that would be different from condo to condo. But your bylaws can set out qualifications and disqualifications of who can be on the board. All right, here's our last question that we have not gotten to. It says, is there any legal backing for non-camera minutes to be posted? Our board creates 2 sets of minutes, one without personal information. So we've kind of touched on this topic, but we'll just wrap it up with this. If we're dealing with in camera, which are minutes that are separate from the general minutes, can the general minutes be posted? And I think we'll let anybody on the panel just give their views on that.
Well, I think there's no legal backing to even require that minutes be posted anywhere. It might be just for ease to reduce the number of records requests, but then you still have to comply with Section 55 and any policies you have around privacy, legal proceedings. So there's a lot of exceptions that you really need to be thoughtful about. It's not just personal information. It could be employee information about their salaries. So we really gotta, it's an actual intellectual sort of exercise to go through. And it's just going to be a policy of the board. There's no real legal backing to that at all. You can ask for it, request it, then the board can consider whether they're going to give it to you or not. Typically they will, but it'll be redacted.
All right. Anybody else want to add to that? Going once, going twice. Patricia's had the final word on it. All right. Okay. So we are going to wrap up this webinar. Thanks for hanging around for an extra 15 minutes. Thank you very much to all of our speakers today, who are also our board of directors. We are all volunteers working to make CCI a great organization for owners, directors, property managers, anyone involved in the condominium industry. And thank you for volunteering your time tonight to join us. Also like to take this opportunity to once again thank our sponsors, Elia Associates, Condominium Lawyers. Thank you, Patricia, and Nordic Windows and Doors. Don't forget to mark your calendar for our upcoming Lunch and Learn webinar series, as well as our director's course. And stay tuned, pay attention to our website because we will also be having an in-person event sometime between now and June. So check out our website for information about that. If you want to find out what is happening on the CCI Huronia calendar, all you have to do is actually sign up to our email blast list. And all you have to do that, free of charge, send an email to admin@ccihuronia.com. Say that you want to be added to our email list, and we will add you to our email list. And that way you'll get information as soon as it's released about anything that's happening at CCI Huronia. Also, if you have any suggestions for topics for future webinars or speakers, you can always send us an email to admin@ccihuronia.com with your suggestions. We love to receive them, and we try to incorporate them as much as we can into our planning. And don't forget, if you haven't had an opportunity to join us at previous webinars, you can always see them, the recordings, on our website or on our YouTube channel. We would love if you would leave a comment or subscribe to our YouTube channel. And if you're looking for what's happening at our chapter or chapters across the country, you can also go to the national website, cci.ca, and find out what's happening under the calendar of events. So until next time, I'm Sonja Hodis on behalf of the entire board of CCI Huronia. We hope to see you at one of our upcoming events. Thank you for joining us today. If you're a property manager, make sure your name is in the chat box. And to everyone else, wishing you a good evening. We hope to see you on February 21st when we talk about the ins and outs of requisition meetings. And don't forget, CCI is your condo connection. Good night, everyone.